This is the case of Castillo versus Castillo. The related provision is Article 1 of the Family Code, stating that marriage is a special contract union between a man and a woman entered into in accordance with the law for the establishment of conjugal and family life. It is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation, except that marriage settlements may fix the property relations during the marriage within the limits provided by this code. The facts of the case: Lea Castillo, the respondent, married Benjamin Bautista on May 25, 1972. She then entered into a second marriage with Renato Castillo on January 6, 1979. Renato Castillo, the petitioner, filed before the RTC praying to declare his marriage with Leah void because of her subsisting first marriage and psychological incapacity. Leah contended that her first marriage was void because she and Bautista did not secure any license and there was no need for judicial declaration at the time. RTC sustained the petitioner's prayer on the ground that the second marriage was a bigamous marriage and that the respondent did not seek judicial declaration for the first marriage to be null and void. Subsequently, the petitioner filed for reconsideration for the distribution of their properties but was denied. Both the petitioner and the respondent submitted their notices of appeal to Court of Appeals. Court of Appeals reversed Artis's ruling and upheld the second marriage valid on the grounds that the second marriage was held before the family code took effect and there was no need for judicial declaration. Thus, this petition to the Supreme Court. The main issue here is whether or not the second marriage is invalid due to the respondent not seeking judicial declaration for the nullity of the first marriage. The ruling of the Supreme Court denied the petition. As far as the nullity of the first marriage is concerned, the old civil code was still applicable to the first and second marriages dated 1972 and 1979 because the family code took effect on August 3, 1988, and the marriages happened prior. The Supreme Court emphasized that the Civil Code's fifth difference between void and voidable marriage, stating that a void marriage doesn't need a judicial declaration, while a voidable marriage needs a judicial declaration. The Family Code couldn't be applied retrospectively as well because it would prejudice the petitioner and his children. That's it. Please subscribe and support your fellow law student here.